Thank you, Mr. Chairman. Gentlemen, I don't want to spend a lot of time on this, but I also don't want to debate how many lawyers can dance on the head of a pin. I think you understand where a lot of these questions are coming from. Mr. Gaiser, would you ever advise a client to ignore a federal district court opinion?
Thank you very much, Senator Kennedy. I would advise it.
Thank me. You can thank me by answering it.
I would advise a client on how best to comply with all lawful court orders.
Is that a yes or a no?
Yes, sir.
When federal courts issue rulings, does every agency and client have to obey? Or can some simply choose which orders to follow? Senator Kennedy's sharp questioning in the Judiciary Committee reveals the murky reality behind court compliance and why it matters more than ever.
You would advise a client not to follow a federal district court opinion?
I would advise a client to follow court orders.
Would you ever advise a client not to follow a federal court of appeals decision?
I had the privilege of clerking on 2 federal courts of appeals.
Is that a yes or no?
Yes. I would advise them to follow the orders of courts of appeals.
How about Supreme Court opinion?
Yes, Senator, I would advise them to follow the Supreme Court's orders, as President Trump has been very clear that those orders are to be followed.
Mr. Woodward, let me ask you the same question. Would you ever advise a client not to follow a district court?
No, Senator.
Would you ever advise a client not to abide by an opinion of the Federal Court of Appeals?
No, Senator. Again, it's difficult to answer in the hypothetical, but...
Would you ever advise a client not to follow an opinion by the United States Supreme Court?
No, Senator. As the President has been clear, he will follow all orders of the United States Supreme Court.
Tell me what I would need to do under the APA, the Administrative Procedures Act, if I want to change a current rule.
Well, Senator, as a senator, you would pass a law that would change the...
No. I don't want to play games here, Counsel. What would one have to do? What would the head of an agency have to do to overturn a current rule or regulation?
Well, Senator, I know that there are many ways to do that, and I don't want to play games either. I want to answer the question.
That's fair.
There are many ways in which an agency can overturn a...
Well, you have to give notice, right?
As a general matter, yes, Senator.
Yeah. And you have to invite input, right?
As a general matter, yes, Senator.
Okay. And sometimes you have to hold a hearing, right?
Sometimes you do, Senator.
Yeah. Are there any exceptions to that under the Administrative Procedures Act?
Under the Administrative Procedures Act, I'm not aware of any exceptions, but there are exceptions under the law.
Okay. Are you familiar with the cause exception to the Administrative Procedures Act?
Senator, I am vaguely familiar with that exception.
Okay. Do you know what it says?
No, Senator, I do not.
So, I understand. Here's what I'm driving at. Are you familiar with the Supreme Court's case called Loperbright?
Senator, I am vaguely familiar with the Supreme Court's decision in Loperbright.
The overturned Chevron doctrine, right?
The Chevron deference doctrine, yes, Senator.
Okay. If there is a rule promulgated by a prior administration or even by a current administration that is in clear violation of the United States Supreme Court's pronouncement under Loperbright, ruling unconstitutional the Chevron doctrine, would it be possible, strike that, would it be prudent for the Justice Department to authority under the good cause exception to the APA in the public interest and forego the notice?
So, Senator, thank you. I think I now understand your question, and that is to the non-APA process. I mean, if a rule has been promulgated that is plainly unconstitutional, it absolutely would be appropriate for the Department of Justice to look at that rule and make determinations.
My point is, you don't have to ignore the APA to do that, do you?
I would say it depends, but I like your point.
I mean, the APA provides an exception.
Yes, Senator.
It's 553 right there, big as Dallas. Am I done?
Yeah.
I thought that was maybe a mouse or something.
Senator Cool.
In this intense exchange, Senator Kennedy presses government legal counsel on a critical question. Should clients always follow federal court orders? The answers are straightforward. Yes, clients should comply with all court rulings, from district courts to the Supreme Court. Yet the discussion uncovers complexities about how administrative rules can be changed or overturned. Kennedy's focus on the Administrative Procedure Act, APA, highlights the legal hoops agencies must jump through to alter existing rules. Typically, this involves public notice, inviting input, and sometimes hearings. However, there are exceptions, such as the good cause exemption, allowing agencies to bypass these steps in urgent cases. The questioning also touches on the Supreme Court's decision in Loperbright, which challenges the long-standing Chevron deference, where courts often deferred to agencies' interpretations of laws. This ruling means agencies must reconsider outdated or unconstitutional rules and act swiftly, sometimes without the usual procedural steps, to protect the public interest. Why is this important? Because it shapes how federal policies are enforced or dismantled. It affects everything from environmental regulations to public health mandates. Understanding these legal dynamics is key to knowing how much power agencies and courts really have, and how that power impacts your life. If you found this breakdown eye-opening, make sure to like, subscribe, and hit that notification bell so you don't miss crucial updates on government and legal affairs. Share your thoughts in the comments. Do you think agencies should have the power to change rules without full public input? Let's start the conversation. Thanks for watching. Stay informed, stay engaged, and remember, understanding how laws and courts work is the first step to holding power accountable.